All right, let me now go to page 11, Mark Munger versus David Mahon. Appearances, please.
Morning, Owner Jeff Hulet on behalf of Holy Games Inc.
Morning, Your Honor. Todd Prall on behalf of the other third-party plaintiffs.
Steven Caloiaro on behalf of Bragg, Your Honor. Good morning, Your Honor. Rory Kay on behalf of the state third-party defendant.
Morning. Should I just take there's several motions on, should I just take them in the order that's on the calendar, or is there a consensus that I should hear them in another order?
Your Honor, I think my two motions were the first filed, so it probably makes sense to take those first and one of the other filed. But
Okay.
I'll defer to the court if they have preference to go another way.
They're not very, they're distinct issues, so however the court views.
Okay, the first item on calendar is third-party defendant T. Maji's motion to dismiss for lack of personal jurisdiction.
Your Honor, it should also be Adam or B, both of the.
Yeah, this is a separate motion, but I can hear them both at the same time.
Yeah. I don't think the opposing counsel has any issue with that.
No, I think it's
Okay.
Your Honor, it's well settled precedent that third-party plaintiffs must show that specific personal jurisdiction exists over each claim brought by each of the third-party defendants against each of the third-party defendants. Moreover, the plaintiffs are required to make their showing with competent evidence of material fact. We've already briefed for the remaining third-party defendants in front of you. The court's already dismissed those parties. Quite frankly, the opposition here was simply a regurgitation of what the court's already ruled was insufficient. Notably, the third-party plaintiffs repeatedly and consistently lumped together the two defendants, making identical arguments in the opposition to the motion to dismiss. There's nothing in there about a specific act committed by Mr. Aviv. There's nothing in there about a specific act committed by Mr. Mateev that would constitute an actionable claim. There's no real material difference between the third-party plaintiffs' prior oppositions to this one here. With respect to conspiracy jurisdiction, the same argument. There's no evidence that each one of the foreign third-party defendants participated in the alleged conspiracy and had an act that took place in Nevada. And then finally, with respect to discovery, the court's already ruled that the third-party plaintiffs had an ample opportunity to conduct jurisdictional discovery and have not completed it the same. Specifically, this instance, one of these parties was filed 3 years ago. They were put in this case 3 years ago. So the time for jurisdictional discovery is long since passed. I'm happy to answer any specific questions the court may have, but I think, again, we have a lot of the same where a lot's thrown against the wall to see what will stick. But if you really drill down into it, the allegations for each of the elements of each of the claims against each of the defendants must be shown with actionable evidence. And much like the other third parties the court's already ruled on, that's just not here. Thank you, Your Honor.
Okay, so basically you're saying that the same basis exists on these motions as the other motions that I
Yeah.
There's no distinction.
I think no distinction is probably no material distinction, Your Honor. I think that at a fundamental level, it still falls apart when you look at the elements of the actual causes of action and wherein each plaintiff committed those specific elements within the state of Nevada's position to get that personal jurisdiction. That's just not here. Again, they talk a lot about the alleged conspiracy and that he had one conversation with Matisse, over in Europe, none of which would bring him into Nevada. Adam is even less. There's no Mr. Arab. There's no specific allegation against him other than at one time he was the CEO and shareholder. Being a CEO and shareholder is not sufficient or essential fact necessary to meet one of the allegations here. Thank you, Your Honor.
It's clear, Your Honor, that the factual allegations that relate to these two defendants were also tied in with the other defendants dismissed. I mean, they're all part of the same allegations
With the other defendants that
were dismissed. But that doesn't mean there isn't a distinction here between why we should have jurisdiction over Mr. Majiz and Mr. RV, where there may not have been jurisdiction over the others. that isn't to say that we agree with the court's ruling, of course, that we think there was a showing of jurisdiction for different grounds on the other plaintiffs, so that's why we included all those arguments here. However, the big thing that Mr. Caloiaro just completely ignores is the fact that Mr. Magees was in Nevada in 2016 and met with Mr. Munger in 2016 in Nevada. And everything that happened since then spurred from that incident, those meetings in Nevada between Mr. Magees and Mr. Munger. And Mr. Munger then contacted Mr. Mahon, and they started to have discussions with Mr. Magees about Oryx, which also is in Nevada, headquartered in Nevada. In fact, they also ignore the fact that there are documents that they produced that show that Mr. Magees signed documents and letters. They were submitted in a protective order, attorney's eyes only, so I have not given them to the court as of yet, but I have an affidavit that says basically what they say in our opposition. And those letters, again, indicate that Magees was here in Nevada, or at least is connected with Nevada in his management role of Oryx, who is the subject of a cell that is the basis of this case. He, more than anybody, we have evidence that he was here. And he spoke with Mark Munger here in Nevada. And it was from that 2016 meeting that all of our other allegations come. And that Mark Munger ultimately became
That's Magees, right?
Magees. Yeah, Matej Magees. That's who I'm talking about right now. So we'll start with him. I'll talk about RV in a moment, but they are connected. So he was here. He talked with Mark Munger here. Mark Munger provided an affidavit in this case that said he met with him here in Nevada in 2016. And ultimately, Mr. Munger, then after this deal happened, where Oryx was acquired by Bragg, through the dealings of both Arviv, Bastian, who was in this case, who was settled with, and Matisse and Munger, all of them benefited from that transaction. Mark Munger became a director of Bragg, Arviv and Bastian became owners, and of course Matisse got a lot of money out of the deal because he was selling Oryx. And the opportunity to sell Oryx is what Mahon thought he had the opportunity to obtain, and through Mr. Munger and these other co-defendants, they usurped that opportunity from him. That is the basis of all of our claims against Bragg and the related parties. And you know that we've had that discussion here before. But the difference here is, again, Matisse was here. He was in Nevada. He was in fact, he's probably been here more than once. We don't know how many times he comes to those conventions, but he has generally come to them pretty regularly. And he was here in 2016, and that's when the impetus of this deal started. And Mr. Munger was clearly here for more than just 2016, and they continued to communicate until this deal where Mr. Munger, who had fiduciary obligations to the full color game parties and Mr. Mahon, was convinced by these other parties to abandon those obligations and do this other deal, which took away the opportunity for the full color game parties to purchase Oryx. And instead, Bragg acquired Oryx, and Munger became a director of Bragg. And again, Mr. Magees was here in Las Vegas in 2016, and that's when he met Mr. Munger. That's number one. Number two, Arviv also is often in Las Vegas, and we believe he was in Las Vegas in 2016 or 2017. Mr. Mahon saw him there with Bastian in one of those 2 years. You couldn't remember which year, but he has been there as well with Bastian, who again, Bastian is the other party who we know that the acquisition of Oryx was done by Bastian through his entity, Arviv through his entity, and Magees through his entities. And we know that Munger was involved because Munger became a director at the time the acquisition occurred in Bragg. And Bragg actually wasn't Bragg before the acquisition, had a different name, and it changed to Bragg as a result of the acquisition of Oryx. And so again, all these other allegations about them conspiring together, they don't all have to happen here in Nevada, but we have some that did. And we know that some did between these parties. And therefore, we think that that's sufficient to bring Maciz, who's been here and who has had actions here, who was a manager of Oryx for a period of time at least, who is headquartered here, who continued to act with Oryx and with these other parties in coming up with this conspiracy to interfere with Mr. Munger and Mr. Bastion's duties to the full color game parties by convincing them to abandon full color game parties in their quest to acquire Oryx and associate with Bragg, Arviv, in acquiring Oryx after the full color parties have the opportunity, and we're pursuing that opportunity. So in essence, the real difference here is these individuals have been here, and they've been dealing directly with people here, and it was from those interactions in Nevada that the rest of the allegations come. Therefore, we think we have established at least enough for jurisdiction over these parties with respect to the interference claims and the other related claims that arise from that. The only thing we have done is we've already asked for Bragg and Oryx, the parties already in the case, to produce all the records they have with respect to communications. Between them and Munger and Maciz and Arviv, because we think that that discovery, or just having those communications, will give us a better understanding of where they were, when, and what activities they did. And those have already been asked for. Actually, the response is due today. So we don't need a lot of time to look at that if the court thinks that is necessary. But again, I think that Arviv and with Maciz, and our opposition papers and the evidence we presented, they are connected to the state, and they directed their activities to this state, and they were here in the state when they first met with and began to associate with the full color party. And therefore, I think that these motions should be denied, that they are different from the other ones. And to the extent the court thinks we don't quite have enough, we've already started the discovery, and we can probably have it in the next 30 days to get those communications to clarify those points. I don't have anything else. No other questions?
Your Honor, let's look at what Mr. Prall actually said and what he talked about. So with respect to Mr. Mativ, there's an allegation that there was a meeting in 2016. That is the only fact. There's no evidence other than I think there was a declaration by Mr. Mahon, Mr. Munger had a text message that there was an alleged meeting that took place. 2 months later, there was a meeting in Berlin, Germany, not connected to the state of Nevada. And he says, based upon this meeting in August of 2016, the court has jurisdiction over this entire case. One simple meeting that we have no idea what actually occurred at the meeting is the basis for a dispute that happened 2 years later. Because remember, the deal that was ultimately the full conspiracy here didn't occur until August of 2 years. So what he's asking this court to do is sanction specific personal jurisdiction based on a single meeting that happened for an unknown number of minutes during a meeting in Vegas that had nothing to do about this. Remember, this was a dinner in Las Vegas at a meeting of muckety mucks for G2E. And based upon this one perchance meeting at a dinner, the court should exercise personal jurisdiction over each and every claim for something that happened 2 years later. And that's the precedence he's asking this court to set, and that's the basis of the jurisdiction. There was nothing else he said. With Adam Arav, it's even worse. He said, we believe he was in Vegas. Mr. Mahon saw him in Vegas. That's it. That's all he's telling you. Based upon the fact that he might have seen someone in Vegas, the court should exercise jurisdiction. There's no other facts he pointed you to. There's nothing else about the specific allegations of this, or the specific elements of each one of the claims showing why Mr. Rav should be hauled into court here in Nevada.
I think Mr. Prall said something to the effect that there's some discovery responses due today that have to do with communications and things like that.
Your Honor, there are discovery responses that are due today. I'll note two things. The first is these people have been in the case for 2+ years. Mr. Majid has been in this case for 3 years. If he wants to wait till after we've refiled a motion to dismiss and then say, oh wait, we need jurisdictional discovery on a case that's been going on for 5 years now, I think that is untimely, and the court is well within its rights to deny that it's within its discretion. And if the court remembers, with respect to the other party's motions to dismiss, he said, oh, well, let us do jurisdictional discovery. And the court has already ruled with respect to the other parties, and this was again 3 months ago, that the plaintiffs have had, and this is from the court order, that third-party plaintiffs had had ample opportunity to conduct jurisdictional discovery, yet have apparently not completed the same, notwithstanding the strict time limitations in this court's previous orders.
Okay, the question I have is, do the discovery responses that are here today bear upon jurisdictional discovery? In other words, are they in that realm?
I imagine that we will be in front of you in 2 to 3 months for these. If you remember, he filed something similar. We came to this court seeking a motion for protective order, or they filed a motion to compel, I don't remember the procedural mechanism. And the court ordered us that we did have to respond because essentially they were forward asking for every document. So the court ruled on a similar set of discovery saying we didn't have to respond. These are almost verbatim the same things that the court's already ruled were inappropriate discovery requests. So hypothetically, could they potentially bear out on this? Maybe. I'm not specifically sure what documents are going to be produced as a result of this. Like I said, in all likelihood, it's going to be back in front of this court because they're the same requests that the court has already ruled were inappropriate.
Well, the question I have is whether I should perhaps continue this hearing and allow supplemental briefing based upon those responses.
And I think the answer would be no. And the reason why is the court's already said third-party plaintiffs had had no fewer than 5 separate opportunities to establish necessary jurisdictional facts to specific jurisdiction over each claim. So the court's already ruled that with respect, because remember, this is the game, right? This is now the 2nd or 3rd or 4th
Well, I
iteration.
understand that, but there may be something in the discovery responses that third-party plaintiffs could allude to in relative to their opposition to these motions.
Maybe, but the point is why now, Your Honor, right? Why we have to file a motion to dismiss for them to serve discovery responses, and then for the court to say, okay, we're going to give you yet again another opportunity, right? They sued him 3 years ago. 3 years
I
ago.
understand that. The question I have is whether they have in their hands the things that they sought discovery for.
And my response to that is, to the extent that they don't, that's their own making and their own doing, and the court shouldn't bail them out yet again.
Well, I thought it was said that responses are due today, and there will be responses, right?
There will be objections and responses.
Okay, so are you telling me that there'll be nothing in those responses?
There's not going to be any substantive document production in those responses. Again, he served, and the case law, we briefed this issue, but the case law is clear from the court as well as Nevada precedent that if you want, you can seek jurisdictional information from other parties, right? And he's had the opportunity to do that. There was other discovery that was done. He could have filed other stuff, but he's not going to get anything today that's going to be like, look, Your Honor, I have the key to jurisdictional discovery. I have the key to specific
So
jurisdiction.
there's not going to be further
No.
and things like that.
My understanding, and I'm reticent to make factual representations of the court that are completely without documentation to back them. My understanding is that this one meeting that took place was a simple meeting where they broached the idea. And this is why, if you remember correctly, Your Honor, they pled breach of contract, and we've asked them, well, where's the contract? And they say, well, you had this one meeting. So everything relates back to the single 10-minute meeting that our guy has no recollection of, that occurred during a dinner in Las Vegas where one of their distributors, Mr. Munger, who's kind of the key in all of this, came and talked to our guy about distributing their games. And that was the extent of it. It was a meet and greet. Someone meets you at a bar event and says, hey, I'd love to come clerk from you. And they sue you 2 years later saying you didn't make them your clerk. That's kind of the
there wasn't correspondence, there weren't emails, there weren't text messages and things like that.
My understanding is no. And certainly nothing that happened within the state of Nevada.
And those responses will so indicate that there's nothing to be produced.
I think the responses will in part indicate there's nothing to be produced or alternatively object on the basis that it's an improper request and meet and confer it to extent to narrow it down. If you remember 2 months ago, we were in front of you because they essentially asked for every communication and they listed 15 different parties and it worked out to be about 1,000 different requests. The court essentially denied their motion to compel or grant our motion for protective order. I can't remember the procedural mechanism. And they've essentially done exactly what they did with the opposition with the other ones. They've just kind of thrown these back over the fence and said, hey, give us every communication you have with every single person about a deal, right? Not related to Nevada, not related to specific issues before this court. It was like I said, you give us every communication about your deal.
Okay. I want to ask Mr. Prall, what were you saying in terms of these discovery responses?
Well, Your Honor, these discovery responses, I don't know if I have the exact responses, but basically We've
The
asked
ones that are
for,
due today, what, the
uh,
ones that are due today, what? do
yes,
they-
that's what I'm gonna talk about.
What do they entail?
They asked for communications between these different parties, Bragg, Oryx, Mahon, RV, Bastion, and Munger. There's several spread out, so I'm not just saying it's one request. Between the time period that issued, 2016 to about, I say 2020, but I can't remember if it's 2018, and relating specifically to the full color parties, communications that relate to that, communications that relate to the deal, the transaction that whereby Oryx purchased, Bragg acquired Oryx, and a couple other small areas. So they all relate specifically to the deal. For us to say, well, we only are going to request communications that happened in Nevada, that doesn't mean we're not limited to that. We're limited to discovery that will help us see when the communications happened and how much they were connected to Nevada. And it's only the 2 to 4 year period, and it's relating specifically to the deals and the transactions that are alleged in this case. That's what we're asking for. The previous discovery was broader, I acknowledge that. But that doesn't mean we can't come back and ask for, narrow our request to do it again just because the court denied those specific requests in the way that they were written. And in fact, this discovery relates to, regardless of whether Matisse and Mahon stay in, this discovery relates to the claims generally, but also specifically to their communications, RV, Mahon's, and Munger's during that time period to see whether or not, we do have, by the way, emails between Munger and Mahon's about a year later. I think they were produced in motion practice previously, but we do have emails between them where Mahon's and Munger communicate. And Munger was here in Nevada for most of that. He was different places, but he was definitely in Nevada. So we do have some emails, but obviously we haven't been able to get Munger to produce everything, and we're not sure if we're going to be able to. And we think there's a lot more. And so that's really what we're looking for in a nutshell. Again, we think that there is connections to Nevada here, and we think that if they were honest in responding to these, we'd at least know or not know whether there's more documents. But it sounds to me like they might just go through these objections again and not produce very much. And that to me is problematic. If we could just get them to say, here's what communications we have or not, then that would be simpler for us.
All right, thank you. So, go ahead. When I proposed the concept of perhaps continuing the on this motion, you objected to that.
Yes.
So it seems to me that if I weren't to continue it, the alternative might be that if I were to grant your motion, and I'm not saying on their rule at this point, but if I were to grant the motion, then third-party plaintiffs could seek reconsideration based upon discovery responses, right?
I mean, yes, they certainly could. I guess that would be, sitting here, I can't remember the statute for reconsideration, but I think it's new evidence that wasn't known or something to that effect could be the basis for seeking reconsideration. But I have the request up, and I can give you a flavor of the type of request that we were objecting to. Produce all documents concerning your or any of your agents' communications with Adam RV between 2016 and 2020. That's the genesis of this, right? Nothing to do, right? And it says including, but it says produce all documents. We've already briefed this in front of the court. The courts have ruled requests for all documents, et cetera, are inappropriate. And then not one of these is a communication with full color. Not one of these is a communication with David Mahon. Nothing. So it's going to be, I guess they do say any other third-party plaintiffs. So I apologize, I don't want to retract that. But it's generally give us all of your stuff, right? And these are to Bragg and Oryx, who we accepted service on the complaint 3 years ago. So again, it's like, why are we here now 3 years later in front of you on a motion to dismiss when they could have served these 3 years ago, and now they're going to tell the court, well, it's due today, we want answers, and then we can respond. They could have done this 3 years ago because these parties accepted service of the complaint and have simply been waiting to litigate the merits of this litigation for 3+ years now.
Okay, thank you. Those motions stand submitted. I'll review them further. The next one is third-party finance capital holdings limited et al. Motion for declaration of entitlement to attorney's fees.
So, Your Honor, I think there's two real key issues here on this. The first is whether they're the prevailing party, and then the second is was this unreasonably maintained or brought.
So it's basically 18.020.
Yes, Your Honor.
basically, it's not based upon a contractual provision, it's not based on an offer of judgment, it's based upon that provision regarding, in effect, bad faith.
That's correct.
Okay, go ahead.
So with respect to the two issues, like I said, is did the third-party defendants prevail on the merits? Did they prevail? And then the second issue
They
is,
didn't prevail on the merits.
right, sorry, did they prevail? Are they the prevailing party? Right. Right, and the key here is, as both parties have argued, that there's a Supreme Court case that talks about, to determine whether a party has prevailed or is the prevailing party, the court looks to whether there has been a material alteration of the legal relationship between the parties. And we submit that your order dismissing, even though it was without prejudice, has created a material alteration of the relationship between the parties. There's two cases on this, the International Institute of Management, where they said the court dismissed the action without prejudice of the defendants and held that the defendants were the prevailing parties because they successfully rebutted the plaintiff's challenge in the action, as well as the double down IGT case. Both of those cases were pretty clear in that as long as there's a material alteration in the change of the relationship, the defendant can be held a prevailing party even if it's not with prejudice. Here, they can't bring these claims in Nevada. They can't relitigate the issues of personal jurisdiction in this court. And the statutes of limitations on each one of these claims have run, and therefore they can't bring suit on any of these claims, right? All of these is...
Well, they could bring it.
They could bring it subject to a motion to dismiss and a renewed, again. The statutes of limitation have run, right? And under the court's theory or analysis, there would never be a settlement, right? And because even if you dismiss the case with prejudice, they could bring it again, right? So that logically doesn't follow that the court would find that basis. As opposing counsel has mentioned, the allegations that give rise to the suit occurred in 2016. None of the statute of limitations still exists to allow these claims to be rebrought in any form because of the statute of limitations. So to the extent that the court doesn't find that by itself the rebuttal or the success of the defendants to not have to come to Nevada and litigate this is not sufficient to make them prevailing parties, the fact that by going through these processes and taking so long, the statute of limitations have expired, there's been a material alteration in the change, i.e. they can no longer sue any of the defendants for the claims that they've alleged due to the statute of limitations. The second issue is whether or not there's merit to this case. I go back to a declaration they issued where they said, we still cannot determine which entity might be the correct one, requiring us to name them all. They admitted to this court, we don't know who to sue, so we're going to sue everyone. That isn't Rule 11, Your Honor. That's in no jurisdiction where there's a Rule 11 type statute or civil procedure rule. Do you get to sue everyone and then hope that somewhere along the line you'll find facts to support your claim? But that's exactly what they did here, right? They had no basis to allege that any of these parties were involved in Nevada. They had no basis to allege that they're proper parties. Again, with the Legacy 8 group, we're like, they're all bad guys, so we're going to sue them all, even though none of those people had any involvement in this deal. There's no allegation that they were involved in this deal, but there's ownership, common ownership between some of the third parties, Mr. Arav, Mr. Spielberg, and these other entities. So they said, we're going to sue them. And again, that's under Nevada law. You can't just say, I'm going to sue everyone, and then I'm going to try to find some facts to support it. That just completely undercuts Rule 11. Nevada case law is clear that we listed 4 or 5 cases wherein the court found that essentially there was no basis for personal jurisdiction, and on that basis determined that fees were awarded to the defendant as a prevailing party. And we listed those cases there. They've tried to say that they're not analogous. We disagree. I think in each one of those, the court comes down to the very basic nature that there were not sufficient facts to support personal jurisdiction, and therefore on that basis, I'm going to award fees to the defendants. And same instance here, right? There was not sufficient facts to find that these people were involved in somewhere in Nevada, and therefore they should be entitled to the fees and costs that they had to expend coming here. The second part of this, Your Honor, is that we've contended all along, this case has never been about the merits. And that's why we're now 6.5 years in, and we haven't even gotten to a full discovery conference. Because this case isn't about the merits for them. They don't want to litigate this case on the merits because there's no substantial basis to the merits. So what do we have? We have a sham motion to stay, where their plaintiff, and we're going to talk about this later today, their plaintiff sues us and then comes in and says, well, we need to stay the case. I want to stay so it hangs over our head. We have improper and incorrect statements to regulators where this court issued a gag order telling him he could no longer make fraudulent representations. We have the preliminary injunction he sought for something he knew about 8 months before the court said, oh, this isn't timely. If you wanted to file an injunction trying to stop the deal, you should have done it when you found out about the deal. And then we have, again, all these irrelevant third parties that are based in the Bahamas or based in Slovenia or overseas. These are all examples of how they were trying to extract a settlement, and they kept and continued to try to make this case difficult without litigating the merits, in hopes that we would just pay them money to go away, in hopes that they would drive down shareholder value, they would stop the spin transaction. All of this was done with the specific intent not to come to a complete and full decision on the merits, but to essentially resolve this case via settlement. And for those reasons, we contend that it was vexatiously maintained.
Okay, you said 6.5 years?
I think this case was filed in somewhere, I thought it was like we're right around 6.5 years, were you correct me on that, about August?
August of 2017.
Okay, August of 2017, Your Honor, is when this case was filed.
Okay. All right, thank you.
I think we're at 6 years then, almost 6 years.
Just to clarify that last point, yes, the plaintiffs who are no longer part of this case brought a lawsuit in August 2017. Bragg was not brought in until at least 2019, I believe, at the earliest. And so just to clarify that, a lot of these parties have not been here for 6 years. In fact, to further clarify that, Mr. Majiz has only technically been in this case for the last 3 or 4 months since you denied their motion to quash service. Mr. Majiz was sued before, but he was dismissed without prejudice, and he wasn't in the case. And Mr. Arbib has only been in for a few months too, just to clarify that. Both of them have only been in since you denied their motion to quash service, which was back earlier in April, because they filed a motion to quash service back in September, but then they didn't set it for a hearing, they didn't request a hearing, and it sat there, and then it was our guys that said, well, we need to set this for a hearing to decide it. So to say that that's all this delay is ours is just not fair. But that really doesn't have very much to do with the motion for fees. The motion for fees, to remind you, is only brought by the 4 defendants who were dismissed. It can't be by Bragg or Oryx or any of the parties still in the case. And the gag order, the stay of discovery, which again, we'll get into more, none of that has to do with these foreign defendants. These other parties are still in the case. And that can be addressed later if it needs to be addressed at all, if they're entitled to any basis at all. This is only the foreign defendants. That's it. And on top of that, first of all, most importantly, there is really no Nevada Supreme Court case or case law that has adopted the United States Supreme Court position that you can have a prevailing party when there is a dismissal without prejudice. Although there's some federal cases, and there's a few cases that kind of address it, that doesn't really directly address that point. Nevada hasn't really taken that position yet, that that's even possible. So number one, they're not the prevailing party because this was dismissal without prejudice. And really, right now, the analysis mostly ends there. They have made these arguments based on the United States Supreme Court case that says there are circumstances where you can be a prevailing party even when there's a dismissal without prejudice. But that case has had other cases since then. We quoted the Fourth Circuit in our briefing that noted the United States Supreme Court case, CRST. It said, following CRST, our sister circuits have held that the dismissal on jurisdictional grounds that permanently bars a plaintiff from reasserting a claim in any forum is sufficient to confer prevailing party status on the defendant. But a judgment that has no conclusive effect on the plaintiff's ability to refile does not confer prevailing party status. And here, that's exactly the case we're in. Nothing in the court's ruling dismissing the claims prevents the plaintiffs from bringing claims in other jurisdictions. Issues of statute of limitations, or when we knew about these different claims, or all those kind of issues they raised, are not issues that you can really decide. It would be in the foreign company, whether the foreign jurisdiction or whether it might be brought within their purview to decide. And so that's the biggest point here, that they don't pass the first prong, they're not the prevailing party. And second of all, I've already addressed that most of the issues they talk about as far as trying to say that it was bought in bad faith under NRS 118, do not even deal directly with these third-party defendants who we brought into the case, and believed we had jurisdiction, but were unable to get all the information that might show that we had jurisdiction over those parties. We believe that the court's ruling that allowed us to do jurisdictional discovery is some indication that there was at least some good faith basis for us seeking that. And just because we didn't get what we believe we did, should have gotten, does not mean that anything was brought in bad faith. With that, Your Honor, unless you have other questions, I don't really have anything else.
All right. Last word on that?
Your Honor, I gotta step out real quick. This motion doesn't implicate me, so I'm fine with everybody continuing without me for a second.
Your Honor, I just have 4 quick points. First, to the extent Mr. Prall implied that this court need not follow U.S. Supreme Court precedent with respect to the case, that's not correct. Obviously, this court is bound by the highest court in the land. So to the extent he said it hasn't been adopted or implied that it might not necessarily need to be adopted, obviously that's incorrect. Number 2, Mr. Prall at no point disputed the fact that there's been a material alteration with the relationship of the companies due to the statute of limitations. This is sufficient under the Supreme Court precedent to find us the prevailing parties. With respect to the willfulness or the malicious prosecution angle of this, or the vexatiously extending the litigation or filing it, he said this doesn't deal directly with the parties. First, with respect to the comment, it dealt that his own client meant, I still cannot determine which entity might not be the correct one, requiring me to name them all. That was the Legacy 8 entities, the entities that are bringing this motion. So it's directly these entities that were, because he didn't know who to sue, he sued them all, thus forcing them to come here to defend themselves. So to the extent he says it doesn't involve the related entities that are bringing this motion, that's not true. That was directly in relation to the legacy. And then the third point, or the fourth point, is that the court's been, and the precedent's pretty clear, that you can take a behavior of a plaintiff or a party in total to determine whether they were vexatiously or needlessly increasing or extending the cost of the litigation. I submit to you that all of these things did that, and therefore we're entitled to these.
All right, thank you. All things considered, I'm not persuaded that the basis of your motion meets the requirements of NRS 18.0102B. I can't determine at this time that the third-party complaints or complaint were brought or maintained without reasonable ground or to harass the prevailing party. The dismissal was without prejudice. I determined that there was no personal jurisdiction. I didn't make a determination on the merits, and I don't find that the motion is supported under that provision, and that's the only provision that's the basis of the motion is that statutory provision. All right, so all things considered, that motion is denied, and I'm not sure if there's going to be any subsequent litigation in another forum or anything like that, but whether or not fees can be sought in that context, I don't know. Okay, so that motion's denied. All right, so now the next one is the declaratory relief motion, I think it is, clarification motion. That's a good 5-year rule.
Correct.
Okay.
It is our motion, so. Your Honor, this motion really is in place of often many parties will reach an agreement on what things happened during the case that might have told the 5 years and submit a stipulation for the court to approve this period for, like, for instance here, COVID, we all agree there was a tolling for a period of time when COVID was, that the 5-year rules was told for all cases. In fact, the parties basically agreed on that point. And if that was a stipulation, we would have just submitted a stipulation. But there was a dispute between the parties on whether or not the stay of all discovery in the case for additional period of time, in fact, told the 5-year rule. And that prohibited us from being able to enter a stipulation, which the court would likely have granted had the parties reached an agreement on the tolling period for the 5-year rule, the court would have entered an order usually granting that and determined that was when the 5-year rule ended. Here, there was an agreement on that, and therefore we brought this motion. Therefore, the first argument the plaintiffs make is that you don't have authority to consider this motion, which flies in the face of the idea that if you could have entered a stipulation or granted a stipulation of the parties on the issue, that you couldn't make a decision had the parties reached an agreement. I believe that you do have authority. The only cases they really cite are cases from the Supreme Court that talked about mootness, where an issue was no longer an issue because of the time that had passed. And then there were also cases where there was a case they cited where legislation hadn't been passed yet, and the people tried to bring a lawsuit based on the legislation being passed. It is not passed yet, and therefore it wasn't right. Neither of those situations are here. This issue is really right before the court, in the sense that there's a dispute between the parties on when the 5-year rule ends, and the court can make a decision now as to the tolling periods that are applicable in this case to toll the 5-year period. And that's what we're asking the court to do. And in essence, our motion suggests that not only was the 5-year period tolled during the COVID-19 period where there's administrative orders from this court tolling the period for a certain period of time, but it was also tolled during the stay of all discovery that occurred for approximately from about the end of June till December of 2021. And so those are the two periods that we believe told it, and that's what we're asking.
Staying discovery didn't stay the case.
That is true, it did not stay the case entirely, but that's not the Supreme Court's analysis for where, for when a stay can toll the 5-year rule. Basically, the Supreme Court's analysis is that, and it's from the Boring case and the D.R. Horton case that were cited. The court's analysis is that any period during which the parties are prevented from bringing an action to trial by reason of a stay order shall not be computed in determining the 5-year period of NRCP 41E. Our position is that a stay of all discovery.
The stay that was sought by the third-party plaintiffs, right?
That's correct, but.
They didn't seek to lift that stay, right?
No, they did not. The other side did seek to lift it. But we would have sought to lift it had we believed it was time to lift the stay. I mean, but understand that under the D.R. Horton case, the plaintiffs sought to stay in that matter as well. So it was a stay that they sought at the beginning of the case because they had to obtain additional procedural matters to bring their case as a construction defect case. So the plaintiffs that brought the stay there and sought the stay, and the court found that stay did keep them from bringing the matter to trial. And the stay of all discovery in this case essentially did the same thing. It kept the parties from bringing the matter to trial for that period that the stay was in place. We're not asking the court to toll it for any longer than when the stay was in place. Their only arguments against that are they cite the California courts to say, well, if it doesn't stay the entire case, it can't toll. Which is, again, those California cases are based on very complicated codes of California procedure that have different tolling for different things. In fact, if you look at the California case, it actually says that stays that are partial can toll the 5-year rule under certain circumstances, and that case actually remanded the case back to the court below to evaluate whether there was a toll that should be proper under those circumstances. And the other case they cite is the Gandor, I'm not sure if I'm pronouncing it right, the Gondor case, Edwards v. Gondor, which is a case where there was a stay that was put in place by the court based on a belief that there was a bankruptcy affecting the case, where the court later determined that the stay was not proper, and the court didn't just lift the stay, the court rescinded the stay in that case. The court actually found that the stay was not proper and rescinded it. And therefore, we think that none of those cases, the case that really applies this case is the Boring case and the D.R. Horton case, that make it pretty clear that if there is a stay order that prevents the parties from bringing an action to trial, that period of time when the stay is in place should be tolled. In fact, in the D.R. in the D.R. Horton case, or it was in the Gondor case that the court found that, whether or not, the issue of whether or not the plaintiff sought to lift the stay or not is really not an issue that has to do with this situation. It's whether the stay was proper in the time that it was, and the court entered the stay, the court ordered the stay, and the court lifted the stay. The court never made a finding that it was improperly obtained or sought, but it lifted the stay when it determined that it was no longer necessary. And it even gave as we noted, the stay was for a criminal investigation, and even gave the opportunity to the criminal investigator, the federal investigators, to intervene to see if they wanted to. They elected not to. It doesn't mean that during the time of the stay it wasn't proper, and the court never made a finding to that effect. The court simply lifted the stay.
What was the context in which those rulings were made? Were
Which
there
ones?
motions to dismiss? Are you in effect seeking an advisory opinion here?
The Boren case was a motion to dismiss. That was a long time ago. It was back in the 80s. The D.R. Horton case was also a motion to dismiss, but we believe that the court has power under Rule 1 to be able to organize this docket and to make a ruling on this so that we can see if we can get this case to trial, and it will help the parties decide what they need to do to move forward.
All right, thank you. I've got to move on to yourself.
Okay.
Good morning, Your Honor. Rory Kay, McDonald Toronto, on behalf of the spin defendants. We filed this as a joint motion. Mr. Caloiaro may have something to add about the SEC subpoena, since he was the one that spoke directly with the SEC, and I believe they actually moved to lift the stay. But I want to start with your two questions, because as with many motions, there are procedural issues with this one, there are substantive issues. You're right on the nose with your question. This is an advisory opinion. We all agree that the 5-year rule, if it runs, doesn't run until November of 2023 because the COVID stay. That's not in dispute here, right? And so NRCP 41E1 lays out a very clear procedure for how the court is to consider and interpret the 5-year rule. It is, as Your Honor noted, on a motion to dismiss. Their motion is premature, and I will point out that they say the problem is with our cases, our advisory opinion cases, they're the moving party. They have the burden to procedurally put a motion in front of you and show that it is proper at that point in time. They haven't carried that. In fact, they haven't cited a single case that gives you the power to issue a 5-year rule, quote, clarification before the 5-year rule has even run. I mean, you can imagine a situation if the court were to entertain that sort of motion, what would stop any sort of party in a case where a statute of limitations is issued from immediately moving at the beginning of the court case and asking the court to issue, quote, a clarifying opinion as to whether the statute of limitations is run, whether the doctrine of laches may apply. That's exactly why advisory opinion doctrine exists, to keep the court out of procedural issues that aren't yet right. But they also have a substantive issue, and this goes to your Honor's question about the stay in effect here. They cite Boren and D.R. Horton. They both basically stand for the fundamental fairness principle, if you will, that a plaintiff shouldn't be stayed from litigating its own case without having the benefit of holding the 5-year period during that time. In Boren, for example, it was the other party that moved for the stay. It wasn't the plaintiff. In the D.R. Horton case, both the defendant moved for a stay, and the plaintiff did have to move for a stay. Mr. Prall is right in that respect, but it was because they failed to comply with construction defect affidavits, which Your Honor is well aware of. And so there was a statute that mandated they do certain things, and they had to stay the case. Both of those stand for the general principle that it is appropriate to pull the 5-year rule when the stay is out of the plaintiff's control. There is no case that they've cited before you today that says it's appropriate to pull the 5-year rule when the stay was within the plaintiff's control and solely a matter of discretion rather than mandated by a statute or some sort of rule of civil procedure. Your Honor is well aware of the stay that was in place in July of 2021. It was implicated by a request from the full color parties and third-party plaintiffs. It was discretionary, not mandatory. They cited no statute that said you had to stay this case. They asked you to do so. because they purportedly were having difficulty complying with its DOJ investigation, which we learned a few months after the fact was a whole lot of nonsense, quite frankly. I will also note that in July of 2021, and I'm sure your Honor is well aware of this, when they filed the motion to stay, we had Mr. Bragg, Mr. Caloiaro on behalf of Bragg and myself on behalf of the spin parties, had motions to compel their discovery responses. That's the real reason why they moved for a stay. They didn't want to answer our discovery. In fact, when you lifted the stay, they still didn't answer our discovery, and you sanctioned them in orders very shortly after you lifted the stay. You awarded fees to Bragg for having to bring a second motion to compel. So this wasn't a good faith stay in the first place. Certainly wasn't a mandatory stay under which they could shelter under Boren and/or D.R. Horton. It was a discretionary stay. In both those cases and all of the other Nevada Supreme Court cases say when dealing with the 5-year rule, if the stay wasn't mandatory, if it wasn't outside of plaintiff's control, you were allowed to consider the plaintiff's diligence in prosecuting their case as an appropriate factor. When you look at that diligence, and I want to be very clear about the timeline here, this case was filed way back in August of 2017 by the original investors of Full Color Games, Inc. The folks over there didn't bring my clients in until February of 2019. That was a year and a half after we were already into the 5-year rule running. They brought Bragg in January of 2020. They waited over 2 years to conduct any sort of discovery whatsoever. They didn't serve requests for production and interrogatories on my clients until June of 2022. In other words, my client had been in the case for 2 years and approximately 4 months at that point in time before they even got on the discovery train. They didn't serve Mr. Caloiaro's clients with any discovery until October of 2022. Again, well over 2.5 years into the 5-year rule running, and they're doing nothing in their case. And of course, I don't have to remind Your Honor that every time we've come before you in the last year, you've reminded us and/or asked about the 5-year rule if it was upcoming, and you would have thought that would have spurred them into action. It
It
didn't.
did spur them into action to file this motion.
No, I think that's true. I will give you that. Certainly didn't spur them into action to do any actual discovery in their case, Your Honor. We don't even have a Rule 16 scheduling order in place right now because they haven't asked Your Honor to implement one. They're still, as you just heard for the past hour, trying to add parties to this case. And so when you look at their diligence, they have not exercised any diligence, quite frankly, in conducting discovery in this case. And that's always because it's been an attempt to force our clients into settlement rather than litigate the merits of this case. So I'm happy to answer any questions you have, Your Honor. I'm not going to touch on the SEC issue.
What's the date of the operative third-party complaint that we're talking about here?
It would have been, so the original first third-party complaint was
I'm talking about
filed.
the one that is operative now.
Yeah, and it's a very good question. There have been so many. I believe it was filed in 2022. But I will also point out that the 5-year rule, and they didn't want to brief this before you because they don't like the answer. When we were talking, when Mr. Prall was talking about the stipulation.
Relates back to the institution of the.
Correct, exactly right. And they were aware of that, and we brought that to light during the parties' negotiations of the stipulation. And so you're right, exactly right. The first complaint here was in August of 2000. They could have instituted a second action against all of these third-party defendants if they wanted to, but they didn't want to do that. They wanted to tie this thing up with 40-some-odd third-party defendants and try and see what they could get in the settlement. You heard a lot about Mr. Bastian earlier. He settled, I think at this point in time, it was over 2 years ago. That has not been an impediment to them conducting any sort of discovery. They just haven't done it. So I think you're perfectly comfortable under Boren and D.R. Horton, and certainly all the other cases to rule against him on this motion. There's just no fundamental unfairness in asking them to litigate a case in almost 6 years since the original complaint was filed. They haven't done their due diligence, they haven't moved discovery forward, and so we would ask that you not extend the 5-year rule. And frankly, and I say this as respectfully as possible, Your Honor, NRCP 41 doesn't allow you any discretion. It says you must dismiss it 5 years. You get to tack on COVID. We don't dispute that, but otherwise there's no basis to hold it until May of 2024.
Two comments. First, I believe jury has been demanded in this case, right? Secondly, I believe that there are equitable claims pleaded by the third-party plaintiffs, right?
I think so, yeah. It's a long complaint. It has a lot of twists and turns to it, but I think that's a fair statement.
Okay, thank you.
I'll be brief. My esteemed colleague did an excellent job with this, so I'll be really quick.
This has to do with the stay, right?
Yes, Your
In
Honor.
general,
Yes.
the U.S. Attorney's position.
Yeah, Your Honor, and I wanted to raise one other point too. The first being that the fundamental unfairness here is for the plaintiffs in this instance to say we need a stay, we demand a stay, and then use that like a sword of Damocles hanging over the necks of a third-party defendant, and then ask this court out of the same mouth to say, oh, well, we want extra time for our stay. Right? That's fundamentally unfair and not the goal or the stated purpose of allowing or extending the tolling period. The second, in an independent basis, was that the stay was a product of misinformation. We've heavily briefed this before the court, but just as a real quick summary reminder, they moved for the stay, we opposed it. We fought like heck to find out who issued the stay and what the basis was. They told the court, you can't release this, it's gotta be in camera. So for 2+ months, we were with our hands on our laps, couldn't do anything about it. And later on, we found out the reason why is because once we found out who the AUSA was, we called him, and he had no idea about this pending civil court case. And remember, they told the court, oh, well, this will give them an opportunity to come file their own objection and seek a stay of the case, which is typically done if a governmental agency feels like a civil case is going to interfere. This will give them the opportunity, the AUSA the opportunity to come. When I called the AUSA, it was, well, he didn't even know about this case. He had no idea that Mr. Mahon was using the subpoena he demanded as a sword in this case to seek a stay. Once he found out about that, within 5 minutes, sent Mr. Mahon an email saying, the subpoenas are gone, I'm not having anything to do with you. And then we immediately filed an emergency motion to lift the stay. So again, this stay was a product of, at best, could be described as what I would say disingenuous information. So that should not, for that independent reason, it's not a basis for the stay.
All right, thank you. Mr. Prall, ask for briefly.
Yeah, Your Honor, I want to just highlight a couple of things. First of all, the case law in Nevada is pretty clear that this issue of who sought the stay or whether it was mandatory or whatever isn't really the issue. In fact, the Boren case in 1989, actually the parties who got dismissal because they didn't bring it within the 5 years on appeal, they said, well, the other side never sought to lift the stay, and so that's their problem. And the court said, no, that's not the rule. It wasn't right for them to have that stay, and even though they could have sought to lift or vacate the stay, they didn't. They still found that the time period when the stay was in place told the time period. So that's the first issue I just point out. The second thing, we have briefed extensively the issue of when the stay was provided because of the criminal investigation. And I would note that there's a lot of disputes between the parties on what occurred there. Mr. Mahon's declaration is very different than Mr. Caloiaro's. We've never actually heard anything from the USA attorney. I can tell you personally that Mr. Mahon originally was contacted by the US DOJ through me. They called me, Your Honor, and I let them talk to Mr. Mahon. So they did know about this action. They knew about it long before. And for him to come and say they didn't is just silly. They knew about this case. They knew about this case the whole time. And those subpoenas were signed by these people. And David explained very clearly that it was them who were directing it, not him. And because they decided to withdraw it, that's their decision. That's their decision to do that. That didn't affect the fact that there was a criminal investigation. And Mr. Mahon thought in good faith that he should try to allow that to occur before he was concerned that he may end up disclosing things in this case that would affect their investigation, and he did not want that to happen. And so that's the reason he asked for it. So I think at the end of the day, Your Honor, you heard all this before. And when you lifted the stay, you lifted the stay. You did not rescind the stay. You did not enter orders finding that you were misled or anything like that. You just lifted the stay. And so that's, for that period again, it was stayed. Second of all, on the issue of 41E and the standing of whether we should bring this now, I think that there's no question, Your Honor, that for the issue of tolling, whether the stay was tolled during a period of time, whether the 5-year rule was tolled, the court should and can enter orders ahead of it to note when the time period was tolled, to allow the parties the chance to see if they can get it done in that time and have an agreement and a goal to set it forth so that we can get the case tried. We believe that we can get this case tried by May 4th. We believe it's technically impossible we could get it tried by November. The final point I would make is they talk a lot about delay in discovery. Your Honor, we have been working with the spin defendants for almost a year trying to get discovery from them. They barely did a response recently where they basically didn't produce hardly anything that we've asked for. So to say that we're the only ones who create delay in discovery is not accurate. We're fighting with them on their discovery too, which it shows it several times.
Right.
And so with that, Your Honor, you have authority to do this. We believe the Boren and the D.R. Horton case make it clear that it's really about whether it was kept from going to trial. It's not about whether the plaintiff sought to lift the stay or not. It's not about all these other issues that they've addressed. And so that's why we would ask that you direct them.
All right, all things considered, I'm denying the motion. I'm not going to render an advisory opinion. I think that this issue would be better raised in the context of setting a trial, motion to dismiss or whatever. We better frame the issue, and accordingly, I'm denying the motion without prejudice to your contentions, all right? And I don't know when this case can be tried, although I have indicated that I believe that there may be some equitable claims that could possibly be tried non-jury, okay, or at least this trial for the purpose of the 5-year rule in that context. So I'm not, it's just a thought that I have. All right, but in any event, I don't consider this motion to be, to make it right for my consideration. The context of the motion to clarify is different from what the context of the motion to dismiss. Okay? So that's the ruling. So I need, Mr. Prall, I need an order relative to the attorney's fee motion.
We
Submit that note by opposing counsel, and then I need third-party defendants to submit proposed order regarding the 5-year rule. Just need at least on the motion to clarify. I haven't made a ruling on the 5-year rule, it's just on the motion to clarify. I've denied that without prejudice to contentions, and I've taken under advisement the motions to dismiss for lack of personal jurisdiction. Okay, I'll issue my ruling almost as soon as I can.
Thank you.
All right, on page